Like this, Derek Lane. All right. Are you Derek Lane appearing there from the jail?
Yes, sir.
All right. This is case number 23 CR 202, State of Ohio versus Derek Lane. This is an arraignment. Mr. Lane, you were indicted by the grand jury on Tuesday on a charge of grand theft of motor vehicle, receiving stolen property, and forgery. Mr. Collins is present on behalf of the state, and has the alleged victim or victims of these charges been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, Your Honor, and they will not to
Right. I see the arraignment entry here, Ben. All right, Mr. Lane, the charge against you in count one alleges that on or about October 9, 2023 in this county, you did with purpose to deprive an owner of their property, a 2008 Chevy Cobalt, obtain or exert control over that without their consent. The second charge alleges on or about the same date in this county, you received, retained, or disposed of a 1997 Ford Ranger, which is a motor vehicle, knowing or having reasonable cause to believe that had been obtained through the commission of a theft offense. So that's a charge of receiving stolen property. And then count three alleges on or about October 9, 2023 in this county, you did with purpose to defraud or knowing you were facilitating fraud, forge a car title so that it appeared to be genuine when it was actually spurious, or to be the act of another who did not authorize that act, or had to have been executed at a time, place, and term different from what was in fact the case. And the value of the loss was over $1,000, but less than $7,500. So counts 1 and 2 are both 4-3 felonies, which carry possible prison term if convicted of between 6 and 18 months, and a fine of $5,000. Count 3 is a 5th-degree felony that carries a possible term of incarceration of 12 months, 6 to 12 months, and a fine of $2,500. Now, you're entitled to have an attorney represent you, Mr. Lane, and if you do not have the funds to hire one, the court will appoint one for you. Is this the first time you've been in court on this case? Okay. You didn't mark it. And who was your attorney in the municipal court, do you remember?
Sarah Barker.
Barker? Okay. All right, the court will appoint Ms. Barker to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bail review hearing on this matter on Wednesday, December the 13th at 8:30 a.m. That'll be a Zoom hearing. We will set your first pre-trial for December 13th at 1 o'clock. I guess we'll just do the bail, we'll just do those both at the same time. No sense in having two of those hearings. So that'll be, both will be at 1 o'clock. Final pretrial will be on December the 20th o'clock. Trial will be set for January the 8th. At 8 a.m. Now, the state's requesting a bond of $5,000.
Yes, Your Honor.
All right. Has Mr. Lane been previously convicted of a felony?
Multiple felonies, 5 of those were
Okay. And has served previous prison terms, looks like.
he has.
All right. Bond will be set then at $5,000 plus your own recognizance, Mr. Lane. That's your promise to appear. If you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll also be required to pay a deposit of $171 that are for statutory required fees. If you make bond, you'll be under pretrial supervision of the probation department, 117 East Main Street. You'll report to them immediately upon your release. Must report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If have no contact with any of the alleged victims, recommended by probation, and be evaluated for substance abuse and mental health issues, and if any treatment is incurred, or any treatment is recommended, then you'll enroll in and follow that during pendency of this action. You'll also be under house arrest at your residence at 5435 Mulback Road in Hillsborough, meaning you have to be there at all times unless you're working, going to and from work. Medical appointments, court proceedings in this or any other case, appointment with an attorney, probation officer, this or any other case. You can attend any kind of schooling, job training, educational programming, etc. You may also attend church services and any holiday family events that you must go to and from. Each of those exceptions directly without any other stops. All right, we'll notify your attorney of her appointment, and we'll have your pre-trial and bond hearing on Wednesday. You have any questions, Mr. Lane?
No, sir.
All right, thank you. All right, this is case number 23CR217, State of Ohio versus Joshua A. Kern. You are Joshua A. Kern, appearing there from the jail.
Yes, sir.
All right, and you are present for the defendant, or counsel?
That's correct, Your Honor. My name is Thomas Kidd. I'm here on behalf of Mr. Kern.
Thomas,
Kidd, K-I-D-D.
and where's your office, Mr. Kidd?
It's in the Mason area, 9435 Waterstone Boulevard. I have a file for discovery, and my address is on.
Okay.
At-
I just need the city for the entry.
Sure. Yeah, Mason, Ohio.
Mason, all right.
Well, actually, it's Cincinnati, Ohio address is what it is.
All right. All right, now the defendant's charged with abduction, a third-degree felony strangulation, a fourth-degree felony domestic violence. The state's represented by the prosecuting attorney, Annika Collins. Ms. Collins, has the alleged victim or victims of these offenses been notified of the time, place, purpose of this hearing, the right to be heard?
Yes, and she is present.
All right. All right. Now, Mr. Kidd, have you had an opportunity to review the indictment?
Your Honor, again, I did review my client's indictment before I came here today. If you had a copy, I do not have a copy myself of the indictment, but I did review the indictment with him.
Do you waive reading the indictment?
Waive reading,
Okay.
and with any 24-hour waiting period, we would also consider not guilty pleas on the 3 counts.
All right. All right, set the first pre-trial on this case for December the 20th.
You're going to check my calendar, which is on my phone.
Sure. Oh, okay. All right, well, we're waiting on the phone to load. Ms. Collins, you wish to be heard on a matter of bond.
Your Honor, we had asked for a $25,000 bond.
How much?
$25,000 bond. Officer Kern has no history. We looked at the serious nature of this offense and the danger that it does pose to the public.
All right, now, does the alleged victim wish to be heard on this?
She does, Your Honor.
All right. You can just stand from there. And what is her name, ma'am? Caitlin what?
Caitlin Kern.
All right.
I don't think that he's okay to be part of society currently. He's not mentally stable. He did try to kill me, and he knows where I'm at. I have nowhere to go currently other than where I am. It's very much, I don't think he's should be out.
All right, thank you. All right, Mr. Kidd?
Thank you, Your Honor. I do appreciate the bond recommendation by the prosecutor in this matter. Your Honor, as Mr. Kern, he's 35 years old. He has one other offense, and that was a DUI reduction. Yeah, we get my mistakes from history. I should represent on that. He works. I provided a letter to the court that the court did receive. Provided also to the prosecutor from his employer, Champion Bridge, which is a company in Wilmington. He's, again, Mr. Kern's been working there for 10 years as a valued employee. I talked to a supervisor from Champion right here. His job is still available, and we'd love to have him back in regard to that. In regard to where he could live, Your Honor, his parents are in the area. He's prepared to live with his parents. And their address is Charlottesville, in Lynchburg. It's not going to go back to the family house, but he will be living there. Your Honor, I'm not sure what this court does. It'd be hard to monitor him, but he's obviously willing to comply with any recommendations the court has in regard to that. But he would like to be able to continue to, well, be able to return to work. And also, in addition to that, be able to see his children, obviously. Two children they had in a previous relationship, they are not from this relationship, and they're 11 years old and 7 years old. And again, we recognize that 46 isn't in play anymore, and I have the allegations of the complaint. We recognize that the allegations of either seriousness are serious. But we would just say, again, the big picture of Mr. Kern is he has life history, has ties to the community, and the fact that he has a job, that we would ask the court be willing to provide a law or a set bond if the court does that, with monitoring.
The address is Sharpsville Road?
Yes, Sharpsville Road, Your
Yeah,
Honor.
that's just right around the corner from Ramble Road, very near the alleged victim's residence. So I have a problem with that because it's almost inevitable they're going to cross paths traveling. So for the time being, I'm going to leave the bond. I'm going to impose a bond of $25,000 cash surety plus an OR, and that is your promise to appear, Mr. Kern. If you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, regardless of what happens in this case, you'll also be required to pay a deposit for statutorily required fees of $116. If you do make bond, you'll be under pretrial supervision of probation department, 117 East Main Street. You're to report there immediately upon your release. Be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing that they may order. Provide phone numbers for home, cell, and employer. Have no contact with the alleged victim. Be recommended by probation. You'll be evaluated for substance abuse and mental health issues. If any treatment's indicated, follow. This or any probation officer, attorney, or in this or any other case. You can also attend any kind of schooling, job training, educational programming, etc., during church services and any family holiday events. You have to go directly to and from those places you have. In the order regarding no contact alleged victim, again, I don't like the residence that you're proposed to be staying at. If there's another residence that would be in a different location, far enough away, there's not a likelihood they're going to see each other on a regular basis. I would entertain a motion to reduce the bond, Mr. Kidd. But at this point, that placement I don't think is a good idea, just because of, and again, the basis for the court's order is that the nature of the offense of public safety and the safety of the alleged victim, and looking at the affidavit that was filed indicated there were visible marks, and that the assault was one, that alleged assault was one that was a result of anger, and so that's all a concern as well the court has. But if you do find an alternate location, then I would consider modification of the bond, again, only on EMHA. Ms. Collins.
Judge, I did want to make you aware the victim is not living in Rainbow address.
Oh, she is not?
Yeah,
Oh, okay.
She is not.
Oh, okay, because she said she had nowhere else to go. I thought she meant she was staying there.
Where she's at right now, she has nowhere else to go.
Okay, where is that location? Where is it?
Street in Lynchburg. So she is with her parents.
In Lynchburg?
Yes, about 3 miles from his parents.
Oh, okay. Well, thank you for bringing that up then. All right. Well, what I'm going to do then is I'm going to reduce it to $15,000. But the EMHA will have to be paid in advance, and I'll put 3 months in advance. I don't know what that is, but that'll be what and so then the Sharpsville Road address will be all right. What is that address again?
It is 3248.
All right. However, when you're traveling to work, you're to avoid traveling through the village of Lynchburg. That may be inconvenient, but it can be done. There are a number of ways to get in and around Lynchburg. So I'm going to put in here no travel into village of Lynchburg. And that's as much for your own protection as anyone else's, because if there is an inadvertent contact, then obviously the person who's being protected would think otherwise and would report that, and we'd be back here for a hearing. So that way it's a preemptive type of situation. All right, anything further? Oh, we need dates. You got your phone up now?
I do, Your Honor. And the 20th works well on the initial pretrial.
All right, so we'll put that at 2 o'clock p.m. That can be by Zoom, Mr. Kidd, if you prefer to do it that way. And if your client is incarcerated, they can do it from the jail. If he is on bond, you can go to your office, or he can appear from another location, as long as he has access to it to be able to be heard and seen and hear what's going on. The final pretrial will be set for, I'm looking at the wrong year there, January, let me wait, look back here. January 17th, 2 o'clock.
That's good as well, Your Honor.
All right, and that'll be in person. And trial will be set for All right, well, actually, I have a speedy trial date here of February the 7th. So,
We are willing to address that, but I assure you, but I'm actually, I have a trial in federal court in the District of Columbia the week of January 22nd through 26th. And I'm doing my own calculation of speedy trial as well, but though my client will be out, and I'll be moved in regard to that.
you believe you'll make
I think I'll move on.
Okay.
I do think you will, but again, I don't want to.
Yeah, I don't plan for the worst case scenario.
Yeah, I do think he'll make bond. I would prefer not to have it the week after the trial in DC, schedule, but perhaps a week after that. And I know that's beyond speedy trial, and we're willing to either file a motion to continue later.
You want to waive time on the record? Is your client willing to waive the speedy trial time?
Your Honor, we did discuss that in regard to that. He knows the potential conflict, and he knew that that might be what we need to do to extend it out. So I would like to waive speedy trial, and I think he is prepared to waive that as well.
Okay.
If you just ask him, that'd be great, Your Honor.
I will do that. All right, so Mr. Kern, right now what I'm looking at is a February date, February 12th. The actual speedy trial date is February the 2nd, although you filed for discovery and some other things.
I just filed for discovery.
All right, and so those things toll and stop it from running until the state complies, and then they request certain things from your attorney, and it tolls until he complies. So most likely it's going to be tolled beyond that anyway, but and so under the law, you have a right to be tried within 90 days of your arrest if you're being held in custody. If you make bond, then that changes. The date is, the speedy trial time is actually 270 days, but you get credit for each day spent in jail, 3 days for one. So that's what reduces it to 90. But if you make bond, then once that happens, then you're going to be losing the 3 for 1. It'll be just 1 for 1. So it'll be beyond that date most likely anyway. And your counsel's got a conflict. And so under the law, the court has to schedule it, and then he'd have to file for continuance, and because it'd be on your motion, then it would be continued anyway and told. So the question is, your attorney said he's all right with you waiving the time, but it's your decision. Are you in agreement that the speedy trial time can be waived? If it is an issue, which I don't think it's going to be, but if it is an issue, through February 12th.
Yes, I'm fine with it.
All right, thank you. So we'll set it for February the 12th at 8 a.m. And speedy trial, I'll make a note here, speedy trial time was waived. All right, are there any other matters then we need to discuss at this time? All right, thank you. And see, on your pleadings, you have your email address on there? All right, so we'll send you notice and the invitation for the Zoom by email. All right, thank you. This is case number 23 CR 216, State of Ohio versus Matthew Scott Jackson. Are you Matthew Scott Jackson appearing there from the jail?
Yes, Your Honor.
All right. You were indicted by the grand jury, Mr. Jackson, charged with having a weapon while under disability, which alleges that on or about October 1 through October 18th of this year in this county, that having not been released from your disability, you knowingly acquired, had, carried, or used a firearm for dangerous ordinance, to wit, a Mohawk 12-gauge shotgun, and you've been previously convicted of an offense involving illegal trafficking and a drug of abuse or illegal possession. Actually, you have 2 of those. So that is a third-degree felony. and the possible penalty for that is between 9 and 36 months imprisonment and a fine of $10,000. You also have been charged with a charge of grand theft of a firearm. So Ms. Collins is present for the state. Has the alleged victim of that offense been notified of the time, place, and purpose of this hearing, the right to be heard?
They have Your Honor, no, it's not here.
All right. All right, so that charge, Mr. Jackson, alleges on or about the period of October 1 through October 18, 2023, in this county, you did with purpose to deprive B, the owner of property, knowing obtain or exert control over that property without their consent. That would be the Mohawk 12 gauge. All right. So you are entitled to have an attorney to represent you, and if you don't have the funds to hire one, the court will appoint one for you. And I believe you filled out a financial disclosure form, and is everything on this form correct?
Yes, Your Honor.
All right. And did you have an attorney previously on this case?
Yeah, I had armor trial when I went in front of Judge Junkins.
All right. All right, the court then will appoint Attorney William Armentrout to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. So the bail review, well, we're going to set this for bail review and pretrial for December the 13th at 1 o'clock. Final pretrial will be set for January the 3rd at 1 o'clock. Trial date will be January the 25th at 8 a.m. And the state wishes to be heard on bond. I don't see a bond recommendation. Oh, no, here it is, 25,000.
Your Honor, Mr. Jackson's prior criminal history is substantial. This court placed him, denied him drug court on September 28th and placed him on community control. And this crime, still an allegation, but was alleged to have been committed between October the 1st and October the 18th, so literally 2 days after this court placed him on community control. Prior to that, he has served prior prison sentences for burglary, I believe a possession charge, maybe you're receiving some property for establishment for based on the danger that he poses to the public, as well as the fact that he doesn't follow any conditions of the court. We would ask that his bond remain $25,000.
All right, court will impose a bond at this time of $25,000 plus OR, which is your promise to appear. If you fail to appear, you could be prosecuted for additional felony if convicted. Sentenced on that no matter what happens in this case. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street, and you're to report to them immediately after you're released, and then once a week for 4 weeks after that as they determine. Undergo random drug testing, provide phone numbers for home, cell, and employer, have no contact with alleged victim, and be under house arrest at your residence. And also you're to pay a service fee of $171, a service fee deposit of $171 prior to release. If you violate any of these conditions, then the court could revoke that bond and have you held till further order of the court. All right. We'll notify your attorney of the appointment. Thank you. All right, are you Russell Eugene Dunn appearing there from the jail?
Yes, sir.
All right, it's case number 23 CR 219. Um, State of Ohio versus Russell Eugene Dunn. Mr. Dunn is appearing by video from the Justice Center. Now, the charge alleges Mr. Dunn that on or about August 28th of this year in this county, you did knowingly obtain, possess, or use methamphetamine, which is a controlled substance, Schedule II controlled substance. If convicted on this offense, you could be sentenced to a term of incarceration between 6 to 12 months and a fine of $2,500, as well as a license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you in this matter. If you don't have the funds to hire one, the court will appoint one for you. And I see you did fill out a financial affidavit or a financial disclosure form. And is everything on this correct?
Yes, sir.
All right. Now, it says currently you were homeless, so you have no residence at this time?
That's true.
All right. Have you been in court on this case before today?
No, sir.
Okay, the court will enter a not guilty plea on your behalf. In the absence of counsel, I'll determine that you're eligible for counsel and appoint attorney Danielle Witt of Hillsborough, Ohio, to represent you. And in the absence of, well, as I said, I enter a not guilty plea in her absence. We'll set a bail review hearing on this matter for Wednesday, December the 13th at 8:30 a.m. by Zoom. Your first pretrial will be set for January the 17th at 1 o'clock p.m. Your final pretrial will be January the 31st at 1 o'clock p.m. And your trial date will be set for February 26th at 8 a.m. A bond will be set in the amount of, well, let's see. Has he been previously convicted of a felony, Ms. Collins? Okay, let me look here. Have you ever been convicted of a felony, Mr. Dunn?
No, this is my first one, sir, Your Honor.
Just what?
This will be my first one.
Okay. All right, I'm going to set bond in the amount of $1,000 plus your own recognizance, which is your promise to appear. If you do make bond, you'll be required to also pay a deposit of $171 prior to release to cover certain statutory required fees, and you'll be required to report to the probation department as soon as you're released at 117 East Main Street, and then once a week for 4 weeks after that as they determine. And we'll go random drug testing, provide phone numbers for home, cell, and employer. Recommended by probation, be evaluated for substance abuse, mental health issues, any treatments indicated. You're required to enroll in and follow that during the pendency of this action. You'll also be under house arrest once you have a residence, meaning you have to be there at all times unless you're working, going to and from work. Medical appointments with your attorney or probation officer in this or any other case. May also attend any kind of job training, educational programming of any sort, classes, college classes, GED, etc. And any family holiday events that may happen while you're on bond.
Your Honor, I always sign up for rehab, Your Honor.
I'm sorry?
I said I always sign up for a rehab center.
Where's that?
Moon in Chillicothe.
Green Lawn.
Mulan.
Oh,
Thank you,
Rulon,
Vice.
okay.
Yeah.
All right, well, I'll have the probation officer, or them get in touch with your attorney, and if there is a bed available, the court will give serious consideration to releasing you there. But it'll have to, I don't have any confirmation of it, and today's, it's late in the day, so, and your attorney's not even aware of it yet. But you can go ahead and call your attorney there from the jail, and when the probation office or somebody from the probation department comes to the jail, if you can talk to them, they can get it to your attorney, and then we can discuss that on Wednesday.
Okay, thank you, Your Honor.
All right. Okay. All right, we'll notify your attorney then of her appointment. Thank you. All right, are you Joseph D. Hauser appearing there from the jail? Joseph Dillon Hauser?
Yes.
All right, this is case number 23 CR 222, State of Ohio versus Joseph Dillon Hauser. This is the arraignment. Mr. Hauser is being arraigned from the jail by Zoom. The prosecuting attorney and assistant prosecutor, Mr. King, are both present. Defendant's been indicted last week, earlier this week, on involuntary manslaughter, corrupting another with drugs, aggravated trafficking in drugs, trafficking, and possession. Now, Mrs. Collins is the alleged victim or victims of these offenses, been notified of the time, place, and purposes hearing the right to be heard, or a representative of the deceased.
The parents of the juvenile, which is deceased, have been notified, and the father and stepmother are in the courtroom taking opposition to speak today.
All right. Okay, so this is case, in this case, Mr. Hauser, you're alleged in a first count of on or about February 3, continuing through February 4 of this year, in Highland County, Ohio, causing the death of V as a proximate result of committing or attempting to commit a felony, to wit, corrupting another with drugs, and aggravated trafficking of drugs. And that's a charge of involuntary manslaughter, a first-degree felony, which, if convicted, carries a mandatory prison term of at least 3 years up to 11 years, set by the judge, with the possibility of that being extended by up to 1/2 by the Department of Corrections facilities. Rehabilitation Correction, I should say. There's also a fine available of $20,000. Count 2 is corrupting another with drugs, and it alleges that on or about February 3, continuing through February 4, 2023 in this county, you knowingly, by any means, administered or furnished to another, or induced or caused another to use a controlled substance, thereby causing serious physical harm. And the drug involved was a Schedule II controlled substance, fentanyl-related compound. That's a violation of 2925.02A3. Felony carries a mandatory prison term between 2 and 8 years, and the possibility, if it's it receives a longer sentence, of it being extended by up to 50% as well, like count 1. There's also a fine available of $15,000. Count 3 alleges that on or about February 3, 2023 in this county, you did knowingly sell or offer to sell oxycodone, and that is aggravated trafficking of drugs, a fourth-degree felony, which, if convicted, carries possible prison term between 6 and 18 months, fine of $5,000 on possible license suspension of 6 months to 5 years. Count 4, I just noticed in the header of your indictment, Ms. Collins, you have 2 count 4s. Count 4 alleges trafficking in a fentanyl-related compound, which alleges on or about February 15, 2023 in this county, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound when you knew or had reasonable cause to believe it was intended for sale or resale by yourself or another. And so that is a 5th-degree felony carrying a possible prison term between 6 and 12 months, and a fine of $2,500, and a license suspension of 6 months to 5 years. And then count 5 alleges on or about the same date, February 15, in this county, you knowingly obtained, possessed, or used fentanyl-related compound. That's also a fifth-degree felony with the same penalties as count 4. All right, now, you are entitled to have an attorney to represent you in this matter. And if you do not have the money to hire one, the court will appoint one for you. And so you have filled out a financial disclosure form. Is everything on that form correct?
Yes.
This is the first time you've been in court on this case?
Yes, Your Honor.
All right.
He does have a children's services case now.
Yeah, I see that. Mr. Wagner is representing the father of the alleged victim.
Yeah, Mr. Wagner representing downstairs.
Oh, it says father on the chart, so it means the defendant.
Yes.
Okay. All right, well, then I'll appoint Mr. Wagner to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. Schedule a bond review at 8:30 a.m. on December the 13th. That'll be by Zoom. First pretrial will be set for January the 3rd at 1:00 p.m. The final pretrial will be February the 21st at 1:00 p.m. The trial will be set for March the 11th at 8 a.m. All right, and the representative of the alleged victim does not wish to be heard on the matter bond?
No.
Anything from the state on the matter bond?
Just a few things, Your Honor. The victim in this case, alleged victim in this case at this time is a juvenile. And the court can figure out reading the indictment, faces an allegation of selling a West per 30, which that juvenile took and died from. So it's a very, very, very dangerous thing that Mr. Hauser does, and it is definitely a danger to society. And based on that, we would ask for the $200,000 bond the state requested in its bond recommendation. As far as prior criminal history, I have received one prior conviction of domestic violence on Mr. Hauser's record.
I do show that there was a warrant issued out of Washington Courthouse back in April of this 2021 on failure to appear, probably in relationship to that domestic violence case, I'm guessing. So the court will set bond in the amount of $100,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll be required to pay a deposit of $171 prior to release. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You report to them immediately upon your release, and then once a week for 3 weeks, and after that, as they determine. You're to undergo random drug testing that may order, provide phone numbers for home, cell, and employer. Have no contact with alleged victims or representatives or family. As recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you enroll in. And follow that during the period of this action. You'll be under house arrest at your residence. Is that Vaughn Road, 44 Vaughn Road?
Wall,
Oh,
484.
Oh, okay. Well, I didn't know there was a Vaughn. Okay, I thought it might be a W. All right, 484 Wall Road in Greenfield, which means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can also attend any appointments with an attorney or probation officer in this or any other case, or any hearings in any other court at any time. You can attend any kind of job training, educational programming of any sort, church activities, and family holiday events if you make bond. If you fail to comply with that, then the court could order you to be held until further order the court have that bond revoked. All right, do you have any questions, Mr. Hauser?
The warrant from Fayette County, for my domestic violence, I did all of my time and got off probation.
That's fine. The only reason I made a note of it is that in that case, there was a warrant for your failure to appear, and that's one of the things that a court has to consider in setting bond is whether or not you're likely to appear as ordered. And anytime anybody's had a previous failure to appear, that's obviously something the judge has to take into consideration.
So is that from this year?
So that's why I put it, that's why I mentioned it. But it doesn't have anything to do with your case in this, anything to do with this particular case, so you don't have to worry about that.
Okay.
All right. All right, thank you.